Welcome back, everybody, to You're Free to Go. Mark's in studio with us. Another great day in Florida. It is raining, but otherwise all good, right, Mark?
That's right.
Yeah, no complaints. Come on now. Remember, fans, please like, follow, and subscribe. Subscribing is free. I had to tell that to my parents. They're like, we love your show. Did you subscribe? No, we're not going to pay. My dad, 88 years old, he's not paying. I said, Dad, it's free. So I guess everyone needs to be reminded that it's free. We have a great episode today. It's, what we do, everybody, we're criminal defense lawyers. A big part of our job when we represent people is we become aware that our clients have some type of mental health issue and a psychological situation going on. Very, very common with people who have been arrested for a crime. So that part of our representation, understanding the psychology of what's going on, is really, really important, having our clients evaluated. So that's what we're going to talk about today. In fact, I think that's what kind of drew me to criminal law is so many of these clients, they have a very productive, successful life, but they have this one dark side, and it fascinates me. And I'll just use the example of Jeff Epstein. He's one of the perfect example. The guy was brilliant, super successful. Everyone loved him, but he had a dark side. He liked underage women in the sexual relationship. So I've always been fascinated by this. So today we're going to talk with a guest who is a doctor, and he is literally the GOAT. We don't need to talk about his resume, but I will briefly, because I'm saying, everybody listening, this is the GOAT of psychological testing and analysis within the court system. And testifying as an expert witness on both sides. He does the state and the government and on the defense side, which gives him tremendous credibility. But he is with the Institute of Behavioral Science and the Law. That's out of Fort Lauderdale, but I know he's handled cases all over the country. He's taught and supervised at the doctoral level. He teaches students getting their doctorate. He teaches seminars to lawyers all over the country. The list is so long. Again, he is the GOAT. He does competency to stand trial, sanity defenses, substance abuse, violence and domestic violence situations, you name it, sex offenders, forensic consulting, et cetera, et cetera, et cetera. Today, we're going to touch on a couple really cool topics: competency, insanity, and one that I'm super fascinated, I think everyone in the world is false confessions. People have such a hard time believing there could be a false confession. And I'm sure a lot of other topics, Mark, are just going to come into the conversation, as they always do on our show, as we banter back and forth. So without any further ado, we're going to welcome Dr. Michael Brannon to our show. Hey there.
Hi there.
Thank you.
Well, thank you both. Thank you for having me today, both Guy and Mark. I appreciate it. I'm not used to being in a room with two attorneys where one isn't yelling at me, telling me I don't know what I'm talking about.
We'll both tell you don't know what you're talking
All right,
about.
that makes sense.
No, seriously, we are in awe of your abilities. We've both had experience with you and hope to again. You've been a wonderful addition to the defense team, and often a wonderful addition to the prosecution team, because you call balls and strikes. You call it
Right,
as you see it.
that's the purpose of it. But I appreciate the kind words from both of you. It's very, very nice. Thank you for having me on.
Well, we're honored to have you on, honestly. So, yeah, let's just jump right into it, Doctor. If you want to share a little bit for our viewers and listeners about your background, just general discussion, and then we'll just go back and forth with some conversation.
So, Guy, I think you did a great job of talking about me already. Let's talk about things that your listeners will be very interested in. I'm a forensic psychologist. I think it's the best thing to start with. And that's where the science of psychology helps to answer or give opinions on questions of law, some of which you mentioned before, things like competency, insanity, and risk assessments, Miranda waivers, false confessions. But it's the way that we can apply the principles that are involved, the scientific principles behind psychology, and be able to assist the courts in getting some information that may be helpful or may not be helpful to a defendant in a criminal case.
Cool.
And so where did you go to school?
I went to school at Nova. Most of my education was at Nova right here locally. So I have my undergraduate degree, my bachelor's degree, my master's degree, and my doctoral degree in psychology, clinical psychology from that school, and spent a lot of time there. And then actually went back and taught at that school, taught in their forensic psychology track program, which I didn't have when I was there, because there weren't many of us doing it at that time. But now they have a whole forensic track that they're training students in, and many of those I've had the pleasure of being able to go back to my alma mater and actually teach there. So it's a great honor to do that.
Yeah, that's great.
Mm-hmm.
Well, one of the things that both Guy and I have experienced, and most defense lawyers have, is coming across clients where we wonder, are they competent to stand trial? Are they really capable of being able to assist in their defense? And should the court allow the trial to go forward? So why don't you tell us a little bit about your experience in that? And more importantly, what are the standards that the law applies in that regard?
Sure. So I'm glad you asked me that, Mark. And I would say this too to your listeners who are in the legal community. In every law school or every group of webinars that I've done or workshops with attorneys, they always say the same thing to me, and judges too, that they had very little training or experience in regards their program, their JD program, their law school in areas of psychology. They had very little training, didn't have any coursework, may have had a guest speaker maybe every once in a while, but their exposure to mental health was really limited, which is really kind of strange because so many of the cases we come in contact with include mental health elements. Now, you mentioned just one of them, and that's competency to proceed. Competency to proceed, just as a brief introduction on that, is based on a standard called Dusky versus the United States. For our listeners, what that really, who don't have a legal background, what that really has to do with is, can a person really understand the legal system, understand that it's an adversarial process, and be able to meaningfully, in some ways, contribute or participate in that process? There's a whole number of things we have spelled out that determine whether someone's competent or not. But that's basically whether a person has a factual knowledge of the system, knows there's a lawyer on their side who's helping them, knows there's someone who's against them called a prosecutor, if there's a judge and a jury. Do they know all of these things, and can they in some ways understand it enough to help you out, give you information about their case, testify relevantly if necessary, behave themselves in the courtroom? So all those things are the important components or standards about a competency to proceed evaluation.
When you do that evaluation, you're forming your expert opinion. What if the lawyer says to you, hey, doc, I can't get anything out of this client. Like nothing they're telling me is making sense. They're not assisting me in preparing their defense. Is that something that factors in?
Yeah, Guy, that's really important. So I always speak to, no matter what kind of evaluation it is, I always speak to the attorney because, of course, they're the best source of information. So one of the things in the competency to proceed criteria is being able to consult with their attorney. So if the attorney is saying to me, listen, when I'm talking to him, he doesn't seem to get it, or she says things to me that have nothing to do with the question I asked, or they can't pay attention for more than 30 seconds before they're drifting off, looking off in a corner. All those things are important to me. And sometimes I even go as far as having the attorney who referred the case to me sit in with me so I can actually observe what happens when they talk with their client. It's a great and rich source of information about how communications can go awry when someone gets into an unfamiliar territory, which is the legal situation.
That's a great opportunity to tell you about my first experience with that. We pepper this with some of our own stories from time to time, and we want to hear from you about any stories you can share. But I was in the criminal justice clinic at Georgetown Law School, and for one semester I was a public defender, another semester I was assistant state attorney. When I was a public defender, the first case they gave me was a robbery case, and I went down to interview the defendant, and I asked him, tell me about what happened, and he said, I'm not the man they arrested. And I looked at him, I said, what? Could you repeat that? I'm not the man they arrested. And every time I asked him a question about the case, he kept saying, I'm not the man I arrested. I knew then there was something wrong there. Either he was a brilliant con man, didn't seem to be, or there was something off. So I mentioned to the supervising attorney, I think you need to get him determined or evaluated for competency. I did learn later on that the court declared him incompetent to stand trial. And when that happens, by the way, doctor, what then, if someone is declared incompetent to stand trial, they just walk away, or what happens in that situation?
So, Mark, first of all, that's a great story, and I would consider that a rich amount of information for me to base an evaluation on. I wonder if they were schizophrenic, meaning out of touch with reality and just didn't realize what had happened, so they couldn't appreciate the charge against them, which is a competency standard. or somehow that maybe they had some kind of dissociative state where they didn't remember what happened at the time because of some trauma that had happened to them at some point. Could be drugs or alcohol that they didn't remember that it was them who was being arrested. Or you kind of alluded to this, Mark, that they could be faking, or what we call malingering.
Right.
All of those things are possible in regards to what happens. The psychologist doesn't make the decision on whether someone's competent to proceed or not. They're giving an opinion. Matter of fact, in every case, we're just giving an opinion to the court, to the judge, or to the jury who are actually making determinations. In competency, it's the judge. And then once a decision is made that they can either go forward with their case, meaning they're competent to proceed after if the judge hears from the doctors, or they're not competent. If they're not competent, there's a number of things that can happen. They can either get competency restoration, meaning they go to classes to learn about the legal system, or they can go to a psychiatrist who medicates them so they're not hearing voices or seeing things. Or if they're a risk to themselves or others, then they can be psychiatrically hospitalized at the state forensic hospital for their competency restoration and psychiatric stabilization. So depending on the evaluations and the judge's determination, will really decide what happens to that person who's found not competent to proceed.
But generally speaking, and I know in the federal system where I mostly practice, what typically happens is they just don't go free, especially if it's a serious crime. They're usually committed to some kind of psychiatric institution for the purpose of continuing to evaluate and determine when, if they are capable of standing trial.
So, Mark, on the federal system, almost always they go to the hospital.
Right.
So that determination, because the charges, of course, can be pretty serious there, but a judge almost always puts that person, unless there's a great argument by defense about how it can be handled on an outpatient basis. With state, there's a little bit more flexibility. Like if it's a misdemeanor state-wise, there's no enforcement power by the court to be able to make the person do competency restoration or get psychiatric assistance. So if they go long enough without being competent, then they may have to drop the charge, both as a felony and as a misdemeanor.
Mm-hmm.
With a felony, it's a little bit different. With a felony, the judge can actually not only force the person into treatment, meaning competency restoration, but under some case law can actually sell, is the opinion, can actually force them to take medication if they're refusing to take psychotropic medication in order to restore competency.
Wow. Now, you mentioned something earlier, you used the term malingering, which is somebody's faking it. So that's really, I guess, where you come in, because it's hard for an attorney who isn't trained like you are to make that assessment. So can you tell us about any interesting situations? We changed the names here to protect the guilty, I guess, or protect our
doctor-patient confidentiality.
Right.
And it reminds me, before you answer this, of, I've had clients come tell me when we talk about taking a polygraph exam, they're like, oh, I read up on it. If I put a little pin, a thumbtack in my shoe and I step down on it, they won't be able to tell that I'm, lying and stuff. So defendants do, educate themselves. So yeah, I'm really curious to hear, Dr. Brannon, how you approach that to know whether the person's faking it or not, malingering.
One of my first forensic cases way back in the day was a case in which I walked into the main jail in Broward County to interview somebody who had an attempted murder charge. And when I walked in, immediately the person who I was evaluating looked at me with a very, very angry tone and mood. And he said, "I'm very offended," was the first thing he said to me before I even had a chance to say hello. And I said, "Why, sir, are you offended? I haven't even talked with you yet. You don't know who I am." And being a rookie forensic psychologist. And he said, "Because I'm the Queen of England and you did not bow to me when you walked in."
Yeah.
Well, I said, "I wasn't aware. They didn't tell me in advance that you were the Queen of England. And I'm sorry because I didn't quite know what to make of it yet. He could be very seriously mentally ill. I can't, eliminate that without having talked to him." So I proceeded to talk to him, and I will tell you that he had told two other doctors the same thing, who believed him and said that he was psychotic and said that he belonged in a state forensic hospital and that he was not competent. But after having talked with him for a considerable period of time, his story began to fall apart and that he couldn't give any specific details or information. And then other areas of inquiry, because our work is basically being a behavioral detective. When I looked at jail records, he wasn't telling anybody else that he was the Queen of England or asking them to bow. And when I gave him psychological testing that's approved as scientific under what's called the Dusky standard, the Daubert standard. I'm sorry, the Daubert standard, which is scientifically provable, empirically based, generally accepted tools that have been peer reviewed. He failed miserably on all those tests in terms of that standard in regards to responding more like someone who was faking than someone who was genuinely psychotic.
Right.
And here was the real key to it. The real key was that people who fake, one of the things they routinely do, or our fancy term is called malingering, one of the things they routinely do is exaggerate worse than the most mentally ill person, or try to be slower intellectually than the person who is the lowest in terms of intellectual abilities. So they'll not be able to do things like this guy didn't. When I asked him what 1 + 1 was, which anyone can basically tell you, he told me 9. And when I asked
Queen would
him,
know that, right?
anyone would know that,
Right.
right? Right. Just what you would hope, right?
Yeah.
And when I asked him too, what planet he was from, he said Saturn. Now, Saturn's an interesting answer to a forensic psychologist because that's a planet. It's in the same classification as Earth. If he would have said Kmart, that would have been a mentally ill
Right.
answer, but Saturn is not. So there's
Fascinating.
ways we have of detecting people who are not telling stories correctly. I just gave you a brief snippet of them there, but
Right.
there are ways of doing that, but we're not infallible. We make mistakes on it
Well,
sometimes.
talking
Sometimes we
about
call people,
mistakes,
yeah.
apparently the two other uh, experts who interviewed him,
Yeah.
they thought he was incompetent, right?
Right, but I could tell you stories the other way around too, though. So I chose that one being here on your prestigious podcast
Yeah.
about how I was the smart guy, but I could also tell you stories about how I was the dumb guy, who I was the one who missed it and everyone else got it. So
Wow.
it's not easy to do, and some people are particularly skilled at faking.
Right. You know, I'm curious. You started that sharing that story with us by mentioning you were going to the Broward jail. Mark and I go into the jail all the time to visit with clients. Less so at this stage of our career than we used to. But like you said, you were a rookie at the time. We used to go all the time, and we'd get locked in there with the client. And you said, charged with murder, charged with arson, all sorts of violent crimes. I'm wondering if you've ever had a scenario where you're in fear for your own safety. With us, I'm not as worried about it because we're there to protect them and save them, protect their freedom and so forth. So I'm just wondering if that's ever on your mind when you visit with clients.
Guy, it's so funny that you just said that because when I teach doctoral students, I tell them keep their eyes open. And the line I use that always gets a laugh is I say, their attorneys are at more risk than we are. They're usually mad at their attorneys, but see us as someone who can help
Not
them
at the
out.
beginning. Not at the beginning. At the end.
And not the beginning, but eventually
Right.
you
Yeah.
may be the target. So,
Right.
True.
guy, in direct answer to your question, I've only had a problem once in a jail, and all it was just a guy jumping up to his feet, who I realized I wasn't 21 years old anymore because he got to his feet before I did. But there was no physical contact.
Right.
I have heard, of course, from some of my colleagues, some incidents that have happened, but it's not that often, especially if the person's in jail. It might happen more often in your office if they're out of custody.
Yeah.
They come in high or in a psychotic situation, but in jail and in prison, less likely.
Yeah, true. Just so our listeners know, when we meet, whether it's you as the psychologist or us as their lawyer, we're in a private locked room. There's confidentiality. So if God forbid a situation does happen, the deputies aren't going to be there in a flash of a second.
Right.
It could take them a few minutes to get to you. So it is at times can be scary.
Yes,
That's why you
a lot
always
of
have to
damage
have a
can
hard
happen.
book.
Yeah.
Yeah, a lot of damage can happen just in 30 seconds.
Yeah.
And think about too, you're dealing with people a lot of times who are career criminals who sometimes you're handing pens and pencils to. That's a wonderful weapon to
Right.
fill out tests or to sign contracts or whatever else it might be. And in a minute, someone can do an awful lot with a pen or a pencil.
Yeah.
Right.
Well, this is a fascinating subject, the competency. We mentioned another one, which was the insanity defense. And that, of course, is, I think, really misunderstood by the public. Could you tell us your experience with it and explain how that works?
Yeah, so unlike competency, which is a snapshot of how the person is doing right now as they sit in front of you, you're trying to give an opinion on what their abilities are to go into a courtroom right now, like what's their mental state as they sit in front of you, or within a week or two after the time of your evaluation. With sanity, it's a retrospective analysis. You're asking the psychologist or psychiatrist to look back in time, sometimes years back in time, at least months usually or a year, and what was their mental state then. So it's a more difficult task. We're much better at seeing things in front of us than we are seeing things behind us, or especially in front of us, like a risk assessment. So the picture becomes a little less clear because you're relying on other sources of information. So a sanity is, what was the person's mental state at the time they committed an offense? And there's a couple of parts to it. Did they have a mental disease, defect, or infirmity? Meaning, was there something wrong with them? Did they have a mental illness or a brain injury? So, was there something wrong with this person at the time that wasn't drugs or alcohol? And as a result, if they do have some problem like that, did it interfere with them knowing what they were doing, or the consequences of what they were doing, or the wrongfulness of what they were doing? So, here's an example. If a person has schizophrenia, and that's our determination by records and people we talk to and body cams, et cetera, did that schizophrenia prevent them from knowing they had a knife in their hand that they could kill somebody with when they stabbed them? Or if they could know that, did they know that it was wrong? So in other words, they feel like they were killing Satan, legitimately killing Satan, or a terrorist who was going to take over, the country. So that's the analysis, and you have to put the pieces together like Sherlock Holmes to be able to come up with an informed answer for how someone was doing back then.
Right. I had a case where a boy was at a university, I won't say which one, and he was in their study hall in his dorm, and he lit the couch on fire, and the whole dorm didn't burn down, but the sprinklers went off. It was a massive problem for everybody. Thank God no one got injured. But it turned out he had Asperger's, and there was testimony that he didn't understand cause and effect. That if I hold this lighter to this couch, the couch can start on fire, could be a massive fire and so forth. Does that play into this? Because that was at the time, of the incident. He had Asperger's and couldn't put two and two together. So does that play into this, or is that something different?
Sure. So Florida's tough in regards to the sanity criteria. It's called a cognitive test. So no mental health disorder is synonymous with insanity. So because you have schizophrenia or bipolar disorder or Asperger's or anything else, which is no longer around, it's all autism spectrum disorder now. But because someone has a condition does not mean they meet any legal standard, incompetency, insanity, anything. Can't waive their Miranda rights, right? So you have to be able to prove the rest of it. And this is, of course, after Hinckley's shooting of Ronald Reagan, and James Brady.
Yeah.
So the criteria changed in many states, including Florida. So it's tougher now. For instance, if you have a mental health disorder and couldn't control your actions at the time, that does not meet the criteria for insanity in Florida. But if you couldn't appreciate what you were doing or the wrongfulness of it, that does. It's a much higher standard. And Mark, that references back what you said earlier. That's why a lot of times attorneys in states like Florida are hesitant to use it, because it most likely is not as successful, or more often is not a successful defense.
Yeah.
Well, in the federal system, I've had two cases where we actually proffered insanity defenses. One was before the Hinckley amendment, the Hinckley shooting of Reagan and Brady, and the second was afterwards. And the way the law changed in the federal system is, it used to be that the burden of proof was on the government to prove that you were not.
True, yeah.
And then afterwards, the burden of proof was on the defendant to prove
Yes.
that he was incapable of the various things you mentioned. That became an almost impossible standard.
Yes.
Yeah.
It's very hard. And what I would say to both of you is that my experience over all these years has been, when there's a really good insanity case, it usually never gets to trial.
Right.
Because it's so good that the state or the prosecution, the government sees it. So it just doesn't get there. It either pleads out, or they just go, to the judge, in a bench trial, and they make a determination on whether he should go to the hospital or she should go to the hospital or not.
Yep.
The ones that are contested, the prosecution usually has the advantage, because juries, even if they're good sanity cases, juries hate the thought that someone will get off from a crime, a serious crime like a murder or an attempted murder, for mental health reasons. So jurors generally don't like that, the jury research tells us, because they believe that someone's getting a get out of jail free pass by saying they have a mental health disorder.
Well, it's interesting you mention that, because just like in the competency, then the question is, when there is a determination of not guilty by reason of insanity, does the person automatically go free?
So that's just such a great question that's so misunderstood by most people, and for good reason. Other than murder, other than a case of first degree murder, people who are found not guilty by reason of insanity usually stay in mental health situations like hospitalizations, things like that, programs, longer than someone would get a jail sentence if they just pled up to the case or lost in trial.
Fascinating.
So the time they spend is actually longer in terms of supervision. So, and again, the exception is murder cases. So that's important to know. What's also important to know is that there rarely is a situation where someone is just let free, even with lower, like third-degree felonies. It's rare. The person at least is going to get some look in terms of a mental health program, a psychiatric hospital initially, who clears them and says they're okay. But they rarely are just left off to their own resources and walk out the courtroom free of any sort of restrictions.
Now, what
Extremely.
about temporary insanity? What
Well, it's
about,
all temporary. It's, remember, it's a legal term. It's not a
right,
psychological term. Insanity doesn't appear in any psychological manual. So all of it is temporary.
Right.
Some mental illness may be permanent or long term, but to meet the insanity criteria, that's temporary. It means just at the time of the offense. It's the only time that would apply. So the term insanity can only happen if a crime happens.
Well, you mentioned when you were talking about your definition of insanity at the time of the incident, you said, but it wasn't drugs or alcohol. So why is that the case, or where do drugs, if someone's under the influence or impaired by drugs or alcohol at the time of the offense, how does that play into this?
So there's a separate standard for that. In the back in the day, we can all say that our level of experience, there used to be something called voluntary intoxication, where if a person voluntarily took drugs but didn't know what they were doing, or alcohol as a result, you could argue that they didn't understand or didn't have mens rea, the criminal intent to be able to do the crime. Florida's removed that. There's something called involuntary intoxication now. Most of the cases we see are voluntary, though. Involuntary intoxication, they slipped something in a drink and commit a crime as a result, or they didn't understand mixing chemicals like an antidepressant and alcohol could create a reaction that would cause them to lose touch with reality. So under those circumstances, you can plead an involuntary intoxication as a defense to a crime. But again, most of the people who we see who have mental illness oftentimes are also combining that with drug or alcohol use at the time of a crime, which makes my job a whole lot tougher to explain what goes in what category. What was the cocaine effects and what was the hallucination from their schizophrenia effect at the time of the offense?
fascinating. Well, talking about alcohol, the first case that I had involving the insanity defense was pre-Hinckley, was back in the early 80s, and it involved a charge of a white-collar offense. And you would think, how do you raise an insanity defense? Well, this man had been drinking repeatedly for years, a minimum of a fifth of scotch in the morning, and then in the afternoon more, and in the evening more. And it got to the point that it had eroded his cognitive abilities. And what happened is, the funny part of the trial was I called to the stand about 23 bartenders. There was a day where you could not get a drink in Broward County because all of them were in court or waiting outside. Short testimony.
You made a lot of enemies that day, Mark.
What happened is the jury found him guilty because they didn't want to excuse the conduct along the lines of what you said, Dr. Brannon. But curiously, they also, when they announced when the verdict was announced, they wrote a note to the judge. They said, "We don't think he should go to jail."
Yeah.
Of course, the judge ignored that, as a judge would.
There's actually some cases on point that talk about, and I think this is what you're really referencing, Mark. It's called fixed and settled alcohol damage.
Right.
So fixed and settled basically means that, yeah, they voluntarily consumed the alcohol, but they did it for so long and with such chronicity that it's damaged their brain.
Right.
Yeah.
That's
So
what
their
we have.
ability to be able to function in a rational, relevant way has been permanently damaged. So it's not the alcohol at the time of the offense as much as their history of using alcohol has changed their brain chemistry and functioning.
That's exactly what we had.
A little story I'll share quickly. At the state level, I had a case where there was a woman who went to a happy hour to meet a friend. She ordered a drink at the bar. She had about 3 or 4 or 5 sips of it, and her friend called and said, "I'm not going to be able to make it." So her friend left, and she pulled about a mile or 2 away from the bar. On the street, her car kind of stopped next to the curb. She was passed out. we were able to go back, and this was we mentioned, Dr. Brannon mentioned involuntary intoxication. We were able to go back and look at the tapes and show that the person next to her, who she didn't know, dropped some drugs in her drink.
Wow, roofied her.
Yeah. So
Yes.
what's very rare for a lawyer is, we haven't really talked about this on the episode, on the podcast, Mark, maybe one day we will, is the option to go to waive a jury and have a judge trial. This was one of the very rare times where I actually waived jury. The government didn't object. We went for a judge trial, and the judge found this person not guilty.
Wow.
Yeah. And so,
Yeah.
but
Hey, Mark and Guy, one thing I want you to know too, it's just an interesting little anomaly, but whenever I see, let's say, someone for a competency evaluation, and I see that there's an excellent possibility of a sanity case, I always initially, the defense attorney who I'm working for in the case winces a little bit. Like, they don't really have any training in that and background in that. They know how difficult it is to win that kind of case. So they always really want to hear me out at length. And then sometimes it takes some real convincing before they decide that's the right way to go. And I think it's because of that hesitancy about this whole thing about proving somebody was so mentally ill they didn't know something was wrong is foreign to most jurors are going to have sitting there. It takes a lot of work to kind of show that and how that works. So again, the initial reaction I get from most attorneys, even really experienced attorneys, is, well, hold on, let's talk about that. And there's some hesitancy to kind of dive into that.
yeah,
Wow.
yeah. Well, I want to pivot a little bit, if we can, to the false confession.
Yes, that
That's
fascinates
what
me.
lay people say that to me all the time when they hear a case. They confess, and they say, then it's got to be true. So would love to, you and I, Doc, have never talked about this, so I'd love to hear your thoughts on false confessions. And I know it's an area of expertise for you.
Right. So I did for many, many years and taught Miranda waiver evaluations and how to show whether or not someone could voluntarily, knowingly, and intelligently waive their Miranda rights. Some could, some couldn't. So I did a lot of work in those areas, had a lot of training, and did a lot of trainings on that. So attorneys would invariably ask me, well, what about false confessions? Because this was really before the Innocence Project and a lot of those kinds of things early in my career. So I was like, sure, that can happen, but let me explore further onto those areas. So I went to an agency called the Reed Institute that does what's called the Reed technique for police interviewing of suspects, because a lot of the cases involved Reed technique where police officers had convinced someone to talk, that it was the best thing for them to do to talk. And I got training specifically in how police officers do the interrogations. And then I started to review some of the research of some people who, Mark, you mentioned on our private conversation, like Richard Offshee
Right.
and other folks in these areas, Margaret Bolko-Vera, who have done a lot of research in the area, Elizabeth Loftus, who told us that there are some situations that occur mostly based upon not abuse as necessarily by police, as much as the technique they use, the powerful persuasive technique they use with some people who convince people it's better to acknowledge things they never did and could not do, rather than deny it and wind up in court and get life in prison or whatever the option might be. So we do know from the Innocent Projects much later in Barry Scheck's work, we know that a sizable portion of people who their DNA exonerated them, the number is like over 20%, actually had admitted to having committed a crime, a major crime that they could not have possibly done. How come? It's police questioning, trying to get accurate confessions, persistence, and people's fear about what could happen to them if they don't just acknowledge something they didn't do.
But that raises an interesting question, because if they don't know, or it's not reported in the newspaper or on TV or whatever, how a crime took place, how could they confess to something that they don't know the details about because they weren't involved? Doesn't
Right.
that
So
sort of fall?
there's so many different varieties of that, right? So some of them, that's one of the ways that police are supposed to be trained. That's how I was trained in the Reed technique, was to get them to, with open-ended questions, to give the details that they shouldn't have if they weren't there. But as we all know, that's not always the way that police interviews go. Police can be so excited that they think they have the right person, because the person they're interviewing, they're convinced that's the right person, and that their job a lot of times is just to get them to admit what they already know, is that they did it. So they ignore, Mark and Guy, things like that. Like, could they give me specific details that I didn't feed to them in leading or suggestive questions? The Reed technique is meant to get them to not be able to give alternative stories or narratives. You continue to interrupt those narratives and only get them to be convinced that it's best for them to say they did this as opposed to that they didn't do it. So that's the scenario. You're turning the world upside down in that little room without windows with one or two police officers talking to you, trying to convince you it's in your best interest because God will approve of that. Your family will approve of that. We've heard all of those stories. Your neighbors and other people who know and love you would feel much better if you would just say you did it rather than continue to deny it because we all know you did.
Does intelligence or levels of intelligence factor at all into it?
Well, here's the answer to that. And this, I'm stealing this from your colleague, Barry Scheck. What I'm stealing from is that he found that it makes you more susceptible, but still people who are very intelligent and people without mental health problems still confess to things they never did, and sometimes very serious things. And that's the power of the technique that's used, the Reid technique developed by John Reid, who was a police officer and a psychologist. So that technique really replaced beating people up or threatening people by police or keeping them in rooms without food and water, coercive tactics. This is a psychological technique that really convinces people that what they should do is give a confession no matter what, even if they didn't do it, that that's in their best interest to do. And that's the scenario that's set up. Well, here's what we know. The Reid technique is really the best at getting accurate confessions from people, but it also increases the rate of false confessions. So along with the tuna that you're trying to catch out in the ocean, sometimes you catch a shark too, and that's not what you want. So the scenario with the Reid technique is sometimes, most of the time, you get really accurate information, but sometimes you get very convincing confessions that never happen.
Right. I'm glad you mentioned you're depriving someone of food or long, because people watch these Dateline episodes and they say, well, I confess because they were going for 20 hours. They didn't feed me. I couldn't sleep, blah, blah, blah. So I just confessed. But I think people believe that. So doctor, are you saying that if someone uses these techniques on me, that they could get me to confess to something that I didn't do? Like, are we all vulnerable to this? Could anyone actually give a false confession if the officer is really well trained and implements their training?
Yeah, Guy, I can't say it any better than you just said that. So that's absolutely the case. We're all with the right techniques, with a skilled enough person to do the interview, and sometimes it's more than one person, that we're all susceptible to saying things that are suggestive. And following leads that people say to us and convincing us that it's better that we do it this way. Remember, you're isolated in a room with police officers who are threatening you, not threatening you directly, but suggesting to you that if you don't say this or acknowledge it, the worst things could happen later on. They say things like, we'll tell the judge, and these are well-meaning police officers who really believe they have the suspect there most of the time, who really believe they have the suspect in the room. And they're saying things like, we'll tell the judge that you were cooperative. We'll tell the judge that you didn't give us a hard time. You came right out and said what happened. You will tell your family, and everybody else will know that you're a stand-up person for doing this. So they reverse the world for them. And so what you and I would say, and the general public would say, and the people watching this podcast would say, I would never admit to something I didn't do, especially a murder. Right. Yes, you would, under the right circumstances and with persuasive enough police questioning.
Well, this reminds me of a plaque that I had on my wall in an old office, which was a big mouth bass with the head turned out with a hook in the mouth, and the brass plate under it said, if I hadn't opened my mouth, I wouldn't be in this situation.
Right.
Mark, but think about that for a minute, Mark. So the position that a person is in who is innocent, who didn't do anything. So what's our natural? I mean, we're jaded because our work here.
Sure.
For the general public who's listening to your podcast, if I just go in and tell the truth and tell them I didn't do it, this will be over and this will be done with. I don't have to worry about anything. I didn't do it.
Right.
But if you're convinced over a long period of time you did do it, and it's best for you to say that by very persuasive people, sometimes people actually take that bait and go with that and say, I did it.
Mm-hmm. Well, I've sat in courtrooms and you see repeat offenders, and I certainly was a prosecutor and I'd look at the files, I'd see this, or sometimes in criminal defense, I'll hear it, where they've been arrested 15 times and every time they confess. So I guess it's an exception to this rule. They just always confess and they never realize that's what's burying them in this case all the time.
Right.
Yeah,
Or guy, they did all those other things. People just assume the police and us as well, they did it again,
yeah,
but they didn't do this most recent one. But the police say, listen,
yeah,
you know, you've been doing this your whole life. Come on. You
yeah,
want, and you think anyone's going to believe you didn't do this robbery? Really?
yeah, really,
And that could be very, and you know what happens the other times. I mean, you're going to go away for a long time if you don't come forward.
right.
So it's very
So,
convincing and very persuasive. And I will tell you that I sat in on exercises there at the Reed Institute where they actually had me very convinced that I should say certain things, not over hours and hours, but just over brief 15, 20-minute interviews
Wow.
with very
wow.
skilled interviewers that I really thought twice about maybe what I said wasn't correct. They really thought about it. They didn't break me but they only had 15, 20 minutes.
So how does this play out in the legal system and the court and the justice system if you figure out that it was a false confession? Is that something that's addressed at trial? Is it a pretrial motion?
So it can be both, and here's the way evaluators, I'll tell you about my piece of it. So I would go in and I would look at the statement and I would see the person's confession. I would see if there were suggestive or leading questions, if the person initially was refuting those. If, like you all had said earlier, the person was able, the suspect was able to give information the police didn't have. I'd give tests of suggestibility, which can be important. I would also give personality tests to see if they're dependent or had any other kinds of issues. I'd give IQ testing, as we know people with lower IQs are more suggestible. Doesn't necessarily mean that case. But you'd look at that and then you talk to collaterals about how this person really behaves. Are they the alpha male or the alpha female in their office? Are they the person who's the leader or the follower? Are they easily persuaded and suggested by other people in general in their life? You'd want that information. And then you'd want to talk to the person about how they felt in that room, in that interview, and why they spoke and why they said what they did. And you can get some rich information by putting together all those sources of information.
Right, right.
Fascinating.
Yeah.
It
You,
really is a
what
fascinating area.
And what I love about this podcast in general is how organic they are and it's a conversation. And Mark, something that you and I face all the time, we actually did a whole episode on this, is how do we defend guilty people? Like, how do we sleep at night? So I'm actually curious, as I just sat here, it kind of dawned on me, Dr. Brannon, how, you're evaluating people that maybe, murdered somebody, maybe they're alleged to be a sex offender, they're accused of that, they're being prosecuted for being a sex offender with a minor. How do you handle it if you evaluate them and your determination is, that there's something that may exonerate this person? How do you handle that? Because we get asked all the time how we can defend these people.
Right. So, it's the system we work in. I'm a stepchild in this system, but I'm still a part of the system from having done it for so long. So I agree to play by the rules that are in that system. And everyone, no matter what they did, deserves justice. That's what the system is based on. So you have to certainly buy into that concept. My role is a little bit different than I can say someone's malingering. I can't help you with this case. But other than that, I can also say that this person who admitted to having done something, it does not look in any way like they could have done that, or who they said they understood their Miranda rights. There's no way they could have. They have a comprehension level of the second grade. So there's no way they could have done that. So even though they may have done something bad, the system has a number of stop gaps in it, which is why they have great attorneys like the two of you who are going to come to their defense. But also it protects the innocent, which I know is more your adage than mine, but I adapt that.
Yeah.
It protects the innocent when you are fighting for the rights of those who have actually done something terrible. It also protects those who didn't do anything terrible and are wrongfully accused.
That's right. Well, it's interesting. You mentioned when we spoke privately that you sometimes encounter situations where you're hired by a lawyer who wants you to examine the client and come up with a defense or assist in the defense, and you make the determination that that's not valid, right?
Right.
Yeah.
So
Yes.
that adds to your credibility in court.
Right. And hopefully that does, a lot of times you never wind up in court when you give those evaluations because of course, the defense.
No, they're not going to call you. I wouldn't call you.
Right. Exactly. So, but it hopefully gives me credibility with the people like yourselves, like you
Right.
and
Right.
Mark, you and Guy, and that that I'm going to be a straight shooter on things. That you don't always make friends by doing that. And the same thing with the state. I've had several cases three last year, where I was hired by the state on what we talked about before, an insanity evaluation, where the defense expert said that it was their opinion the person met criteria for insanity, and I agreed. So in those cases, those state attorneys, I'm sure, weren't thrilled, but my opinion is they should have been thrilled. because as ministers of justice, they got at least what I believe to be the truth. And I agreed with my colleague from the other side that that person didn't met the criteria for insanity. That's the truth.
Mm.
And that's what we should be looking for in the system.
Well, this has been
Yeah.
fascinating here today.
I just want to point out one thing to our listeners. If I were listening to this, I might say, well, geez, if I have a loved one or myself is being prosecuted, maybe I don't want to do a evaluation, or I don't want to do a polygraph exam, because what if it comes back, and it's not favorable, right? So I want our viewers and listeners to understand that the government doesn't, from the private defense side of the case, the government doesn't know that we're doing this. So I've had many polygraphs where I take it, the government has no idea I'm putting my client on a polygraph. If they don't get a result that's helpful to the defense, the government never finds out we took it. And I imagine it's the same thing on on a psychological or psychiatric evaluation. It's something we're doing and working our case up that the government may never know about. Do you
Guy,
want?
when I get a case like that from you or Mark, I always tell them, listen, you have great attorneys. I've been around doing this for a long time. The best thing you can do is tell me the truth and let your attorneys handle whatever the truth is. They'll guide that. It can't hurt you in any way, but tell the truth and let them know what that is. And that's the best way they can help you.
Yeah, we hate landmines.
Yes, we do. We do. Is there anything another case there's two that you want to share as we start to get close to? We try to keep it between 45 and 50 minutes. We're getting close to 45. I know you were involved in the Parkland case, which is a very, very famous case, a tragic, horrible case. Or any other cases that, as Mark said earlier, we never disclose confidential information that you want to share with us as we kind of start to wrap it up?
I do, Guy. Yeah, so here's you mentioned it. So for some reason, there's ongoing fascination with a couple of the cases I've been in, but especially the Parkland case. I've actually lectured all around the country on the Parkland case, on what happened there, because there was so much reliance on mental health. And I even had the pleasure of talking to I worked for the state. I was a prosecution witness on the Parkland case. But I lectured with the defense attorney, the lead defense attorney, whose name is Melissa McNeil. I lectured with her on this case as well. So I really had a chance to bring in all sides of this. And I lectured to a national group of forensic psychologists, close to 1,000 across the country on this case. There was such interest in it. And here's what I'd want to say real quick on that. What I'd say is there was over 40 different mental health people who, between the defense and the state, had involved in this case. Over 40. And I will also tell you that there were many different diagnoses and many different opinions. There were so many different opinions that we couldn't fit them all into testimony for both the state or for the defense. They had to narrow them all down. But here's the important thing to know. The important thing to know is that what won the day in that case for the state, won the day means he got life in prison as opposed to the death penalty. That was the win the day, was the establishment of there were mental health symptoms, specifically fetal alcohol syndrome, among other things. But that won the day for them. The mental health issues and presentation of that something wasn't right with this young man, and it was provable through their experts, actually wound up having him avoid the death penalty.
Yep.
So sometimes, no matter how many experts you throw into the mix, it doesn't become confusing. It helps to be clarifying for juries as to what was going on. Now, I disagreed with their experts, but they won the day with the mental health defenses and wound up, sparing his life.
Amazing, amazing. I don't think our viewers have any doubt that when I opened the session said that you are the GOAT of forensic psychology. It's clear that you are.
That's so sweet. Thank you very much for that.
Absolutely.
Yeah.
And this
Deserved or not, I appreciate that.
Yeah.
This is wonderful, and I think it was extremely educational and interesting to our listeners and to us.
Absolutely. It
And
was.
we can't thank you
Yeah.
enough for appearing here. And
And I do want to mention he does cases all over the country.
right.
Probably even outside the country, I imagine. But
Just in the country, but I thank
Okay.
you both. It's an honor to
Yeah.
be here with both of you. So thank you so much. I've known you both for a long time, so it's a great honor to be here with you.
Likewise. Thank you.
thank you, Doctor.
Well, we
So-
always sign off the same way. Mark, you want to do it?
Yeah, we always say to our listeners, until the next time, you're
free to go. You're Free to Go is sponsored by Lang Realty, South Florida's premier residential real estate broker. Whether you're buying, selling, or renting a home or condo, Lang's experienced realtors are standing by ready to help you. Contact one of Lang's top realtors today at 561-703-2427. Everything expressed and discussed in this episode are the opinions and experiences of attorneys Guy Fronstin and Mark Nurik and their guests. All ethical rules are complied with. Attorney-client privilege and confidential information is not shared or released during these episodes, and names, dates, locations, and other identifying information may be changed to protect confidentiality. Topics are embellished, and none of the statements made constitute legal advice and should not be considered or relied on as such.